Hello everyone, and welcome to our first webinar for 2025. I trust that you all had a good break over Christmas and that you're back and raring to go. Apologies for starting a couple of minutes late. As it always happens, we were experiencing a couple of technical difficulties, but I think we should be all good now, so hopefully everyone can hear and see me at the moment. For those of you who don't know me, my name is Kate Chalker and I'm an associate with the firm based in our Sydney office, and presenting our webinar today will be Adrian Bailey, who is our managing principal, also based down here in Sydney. And in today's webinar, Adrian will be looking at the different tax aspects of leaving a roof over a loved one's head without the actual ownership interest. So, for example, when you leave behind a life interest or a remainder interest or a right to occupy, for example, what are the different tax implications of those different interests? Can they vary from a tax perspective? And of course, the answer is yes, but Adrian will take us through all of the nitty-gritty details of those different interests. Just before we dive into the webinar, a little bit of housekeeping in case anyone is new to this platform. So if you would like to download a copy of the PowerPoint slides, you can do that by clicking on the Files button on the right-hand side of the screen. And from there, you'll be able to download a PDF version of the PowerPoint slides. Another thing, if you do have any questions throughout today's webinar, feel free to submit them by clicking on the chat button, again on the right-hand side of the screen, and you'll be able to type and submit your questions there. Just a note on the questions, it is quite a long presentation today, quite a bit of detail for Adrian to get through. So just for today's webinar, we will be leaving the questions to the end of the webinar. So feel free to submit them at any time, but I won't be interrupting Adrian throughout the course of the webinar with those. We'll just be dealing with those at the end of the presentation. And also, just due to time constraints, if you could keep your questions general in nature. If you do have any particular client scenarios that you would like some assistance with, feel free to contact Adrian or myself after the webinar with those details, and we'll be happy to get back to you separately on that. But just for today, if you could keep your questions general in nature, that would be appreciated. And last bit of housekeeping is just to mention that today's webinar is being recorded and it will be uploaded to both our website and our YouTube channel in due course. All right, so with that out of the way, I will hand over to Adrian to kick off on today's topic.
Thanks for that, Kate, and welcome to the webinar, everybody. We are going to cover off on quite a few things today, and it does get fairly technical, but as Kate said, if you've got specific queries, probably because there is a lot of things that you need to go through in order to answer specific queries, you can obviously reach out to us separately, or even if you type it in and we can come back to you separately because we'll get a record of that. So what we're going to talk through today in our agenda is that why the exact terms of the will relating to the use of the main residence can impact on the tax treatment. A very quick recap on deceased estates and the main residence rules and how they would normally apply, and the sorts of things that we can do in relation to variations of the normal rules. Whether the main residence CGT exemption can apply to a property held in trust for the lifetime use of a particular beneficiary in accordance with a will. What the tax consequences are when setting up a life interest in a property for a family member prior to death. So sometimes clients will want to do that. Tax implications if both the person with the life interest and the remainder owners request a wind up of the arrangement. And we're going to deal with a fair bit of the paper is going to be going through the different variations of that. Granny flats, touch on that. If you're unaware, there is a specific granny flat exemption for CGT purposes if you meet certain requirements. Some cost base issues in terms of CGT cost base, touching on land tax, but we're really not going to dig into that too much. and then quickly cover off on a case study, having a look at a couple of different taxing points of the life cycle. And like with most of our case studies, it's taken from a client file with relevant details and names and so forth changed. So jumping into it, first off is why the exact terms of the will relating to the use of the residence can impact on the tax treatment. I mean, in short, when you're a lawyer, drafting matters. Remember my mentors drilling into me that you've got to make sure that you're specific with your drafting and it is accurate based on your instructions. It's probably not until you've had the pleasure of being cross-examined over something that you've drafted, usually by a barrister who's had a couple of weeks to review it and examine every word, that you realise exactly how much drafting matters. But where it's important in this part of the world is the drafting will depend on what sort of interest we are creating. And so when we're talking about interest, we're talking about interests in terms of the property. So is it an equitable interest? Is it a legal interest? Or is it a mere right to occupy? And depending on which one of those it is, the tax considerations can be different. And so that's why it's important. It can also have, from an income tax perspective, it's also important for state-based taxes in terms of what sort of interest that we are creating. So we will cover off on each of those three broad types of interests. I'll explain what they mean, because recognising that the majority of people on the webinar are accountants as opposed to lawyers, and then run through what the tax consequences of creating them or ending them are, where we have the use of a property. So pretty common these days, I'd say, where a client wants to leave an asset like a primary residence to either a protected environment, like a testamentary trust, or a particular beneficiary, but allow someone, very often the spouse, to reside in that property. And particularly common, I find, where you have blended relationships. So you will get these queries from clients: how do we do it? What are the considerations? So hence we're going to run through them today. A very quick recap of deceased estates and the main residence rule recap. So normally, I say normally, nothing in life is normal, but in most estates that you're administering, we can make ourselves use of the full exemption contained in section 118, 195. And all references in the webinar today are references to the Income Tax Assessment Act 1997. So that's where all our CGT provisions live. In order to get that full exemption, we have to have a dwelling, and it has to be in the main residence of the deceased and not used for income producing purposes at the time of death. Our taxpayer is an individual in relation to this exemption. It passes to them as a beneficiary or as a legal personal representative of the estate. So we can avail ourselves of this exemption if it's held by a beneficiary of the estate, or if it's held by the LPR or executor. In the tax world and in the tax legislation, an executor is defined as a legal personal representative as opposed to executor. It's disposed of within 2 years, and the Commissioner does have the discretion to extend 2 years of the date of death. The Commissioner does have the discretion to extend that 2-year period, and that discretion is contained, or the way that he will apply that discretion is contained in Practical Compliance Guideline 2019-5, where they state that in order to exercise the discretion to send it past 2 years, you have to show that during the first 2 years, more than 12 months was spent addressing one or more of the following situations. So either the ownership of the dwelling or the will itself is challenged, a life tenancy or other equitable interest given under the will delays the disposal of the dwelling, the complexity of the deceased estate, settlement of the contract is delayed or fall through due to reasons outside of the control of the taxpayer, and what was put in there for COVID, not so much relevant these days, restrictions on real estate activities imposed by government response to the COVID-19 pandemic. So we have to have one of those conditions to begin with in order for the Commissioner to say that they will exercise their discretion. Then we also have to have that the dwelling was listed for sale as soon as practically possible after we'd resolved that situation. Sale was completed within 12 months of the dwelling being listed for sale, and any of the following were not material to the delay, either being waiting for the property market to improve, or waiting for refurbishment, or delay by the trustee, beneficiary, or executor generally. Having said that, the Commissioner will still only extend it for another 18 months past the 2-year period under the practical compliance guideline. An alternative road to that, where we're holding it for more than 2 years within section 118195, and we either can't or we've gone past that effectively 3.5-year period with the Commissioner's discretion to extend, is where from the time of death to the date of disposal, it was used as a main residence by the taxpayer, spouse, or a person having a right to occupy under the will. So that's how, if we have a surviving spouse and they continue to reside in the property, why there's still no CGT on sale of the property. Like with many things in the tax legislation these days, there is a carve-out for foreign persons and what they call an excluded foreign person or excluded foreign resident. And that is someone who has been a non-resident for more than 6 years. They can't avail themselves of the CGT exemption in this circumstance. If we don't meet the full exemption within 118195, then 118200 can give us a partial exemption. So in essence, what happens is that the capital gain is apportioned between the main residence days and the non-main residence days as compared to total ownership period. This can also be further adjusted if the dwelling is inherited from a person who had previously inherited it under 118205. So jumping back to our topic, now that we've had a very brief recap of what often occurs, and the question, does the main residence CGT exemption apply to a property held in trust for the lifetime use of a particular beneficiary in accordance with the will? The short answer is yes, and that's contained within section 118.210.1. So in that section applies if you acquire an ownership interest of a dwelling as trustee. So now in this circumstance, trustee is defined to include a legal personal representative. So this could apply to either the executor acting as legal personal representative, or it could also apply of the trustee of a testamentary trust under the will. The second part that we need, though, is that in accordance with the will, an individual is given a right of occupation of the dwelling. Section 118.210.3 occurs if we have a CGT event to that property. So they have a later sale of the property, money or property is received, and if it's the main residence of the individual who was given the right from the date of death to the CGT event, we don't have any capital gain or loss. So in short, we can apply the main residence CGT exemption to a property held in trust for the lifetime use of a particular beneficiary in accordance with a will. If those factors aren't present, then there is the potential to apportion it in a similar way to what we've just discussed to 118.200 within section 118.200, and that's by section 118.210.4. So again, we have a apportioning between main residence days and non-main residence days as compared against total ownership period. Again, there are some carve-outs to this section. So it only applies to certain CGT events, and we'll come back to some of the CGT events that this section can't apply to later on, and compare that against what the tax outcome is in that circumstance. So we've got the A events, some of the A events, B, C, E about creating trusts, F and Ks, and I events if it occurred before 7:30 p.m. ACT time on the 9th of May 2017. Our exemption can only apply to a forfeiture of a deposit if it is part of an uninterrupted sequence of events that it ends in one of those CGT events. So if you have a situation where we enter into a contract, the deal falls through, and we have the deposit forfeited, we can still have a full CGT exemption if we then enter into another sale contract and it's sold under that second sale track. If we then withdraw the property from sale, though, there will be a CGT event on the forfeiture of the deposit, and we won't be able to use the main residence exemption within 118.210. Again, we can't use 118.210 if the deceased was an excluded foreign resident, so somebody who's been a foreign resident for more than 6 years. So, depending on what the nature of our interest is created, will impact on what our tax consequences are, whether we're starting these arrangements or we're ending them. The three broad types, coming back to property law in my days as a university student and the law of property, the three types of interest that we could either create now, so inter vivos, or by will, would be an equitable life and remainder interest, a legal life and remainder interest, or a right to occupy. So those are the three types of interest we can create via our will. As to what we are creating will depend on the wording within our will or what we're doing during the life of the person if we're establishing it now. And as I said before, the exact drafting of what we're trying to achieve. So what, for the non-lawyers on the webinar, what do each of those interests mean? Or perhaps even the lawyers on the webinar who weren't really paying attention in property law. An equitable life and remainder interest is created where property is effectively held on trust. And pursuant to the terms of the trust, an interest is created in the property for another person. So we have a trust that creates an interest in property for the benefit of a person. That's an equitable life or remainder interest, or equitable life and remainder interest. If we were to create such an interest during the life of a person, then it will likely be the result of either a declaration of trust or transfer of a trust to an existing asset. Either way, we have a CGT event, being either CGT event E1 under section 104.55 or CGT event E2 under 104.60. So E1, settlement or declaration of trust, E2, transferring a property to an existing trust. For the original owner or taxpayer, there is a capital gain or loss, depending on the capital proceeds or market value of the property. So just to recap, this is something we're creating during the lifetime of a person. If no proceeds are received, then the market value of the property is deemed to be the proceeds, thanks to the market value substitution rule. For the trustee of the trust, the cost base is equal to the market value of the property. So that's pursuant to 104.55.4 or 104.64. So regardless of what proceeds are paid, and often when we're declaring a trust over property, we're not actually paying proceeds. For both the person declaring the trust and the trustee, the market value substitution rule will apply. So we will have a CGT event at current market value, and then we will have a corresponding cost base at market value for the hands of the trustee. The interest holder, so the person who is given the life interest in the trust or the interest to occupy a property in a trust, also has a cost base, being the market value of that interest. Dealing with real property, all states there's also going to be duty payable on the transfer of the property or declaration of trust. And depending on the type of property, GST may be a consideration. Very often we're dealing with residences here, so GST is not a consideration. But there may be a mixed use asset or something along those lines where we also need to consider GST. So if we're creating a legal life and remainder interest, so this is not an equitable interest, this is a legal interest. So this can occur where we have a disposal of an actual part of an asset, with the part not being disposed of, then being called the legal remainder interest. So the transaction itself causes a CGT event, which if the beneficiary of the interest is an individual or company, it will be CGT event A1 under section 104.10. Otherwise we're back to E1 or E2 if we're going back to a trust. Again, a capital gain or loss will be made depending on the proceeds or market value as compared to the cost base. And for the life interest holder, the cost base will either be the amount paid or market value. And again, there's also going to be duty payable. And potentially we may have to consider GST. So this is where we're having a part disposal of an interest in property. So we're not declaring that the entire property is held on trust, We're just declaring that part of the property is disposed of, and what we're left behind is the remainder interest. A right to occupy is what you would call a personal right. So under property law, we have personal rights and we have property rights. The difference between the two is a personal right is, like the name says, something that is personal to me if I hold that right, and I can't assign that right. So other examples of personal rights are things like the right to vote, the right to grant a power of attorney. That's a personal right. But if I'm granted a mere right to occupy in relation to a property, and it's not going so far that it's either creating an equitable interest or a legal interest, then I have a personal right which can't be assigned. When you're creating a right like that, then we have CGT event D1 occurring under section 104.35. In most scenarios, the granting of the right on its own, without anything else, will not cause any taxation issues under CGT event D1, as the grantor will only make a capital gain if the capital proceeds from granting are more than the incidental costs in creating it. So it would only really apply if I'm paid something for granting the right to somebody to reside in the property. The market value substitution rule doesn't apply to CGT event D1 where there are no capital proceeds at all. So again, it's unlikely to be creating a CGT event. It creates a CGT event, but unlikely to be there any tax issues when we're creating a right to occupy. As I said, unless there's unusual circumstance where somebody pays you $100,000 in order to be granted a right to occupy in a dwelling. For the grantee, so the person given the right to occupy, the cost base is the amount paid for it. Again, if there's nothing paid, then there is no cost base. And again, the market value substitution rule can't apply in this circumstance. What also can't apply is CGT event D1 is the main residence exemption. If you remember going back to those provisions, and I'll just jump back to them here as to what it can apply to, we don't have D1 on that list. So with that, and that's also excluded in other parts of the main residence exemption. With that, if we do have the scenario where it's a residence and somebody is paid to be given, somebody pays to be given a right to occupy, then we will have CGT event D1, we will have a taxing event, we won't be able to apply the main residence exemption in that circumstance. So moving on to the main part of the paper and the tax implications if both the person with the life interest and the remainder owners request a wind up of the arrangement. And this could happen in a variety of ways, and we'll work through each of those. It'll also depend on whether we have an equitable life and remainder interest, whether we have a legal life and remainder interest, or whether we have a right to occupy. Now, the ATO don't make the law, except in very limited circumstances where the Commissioner has the ability to change some aspects of the law, and they don't, but they do provide interpretations of what they see as the law. They aren't always right, but in Taxation Rule in 2006-14, there is a number of different examples run through where the Commissioner puts out their view as to what they will think the tax consequences of ending a interest or a right to occupy are. So if you are ever looking at a scenario, it's probably a good start to go and have a look at that to see if there's a corresponding example in relation to what your client is asking advice on. Of course, you don't have to follow what the Commissioner says. And again, speaking of mentors, I can hear some mentors talking in the back of my head saying now, just because it's there doesn't mean it's right. But if you go to it, you find an example that matches your client's circumstances, it's in your client's favour, I don't think you're going to have much of an argument with applying that. So, running through the different scenarios if we have an equitable life and remainder interest. So the first one being, so this is where we have effectively a property held on trust. If we have the life interest or the remainder interest disclaiming their interest. So in order for this to occur, we need to have what's called an effective disclaimer. And there's been plenty of case law over the last few years about what constitutes an effective disclaimer. Very often, it's when you're getting an assessment for tax purposes that you don't want to have, particularly where it's a default assessment, and you're looking to disclaim that assessment or that interest. So in order for it to be effective, it must be intentional and show that the nominated life or remainder owner rejects the interest. If you have an effect, so effectively, as soon as you become aware that you have this life interest or remainder owner interest under the terms of this trust, you need to disclaim it immediately. You can't have benefited from it. You can't have received anything from it. You can't have let it just sit there for a while before you disclaim. It has to be effectively immediately as you become aware of it. If you do that, there's no CGT event occurring to the life interest or remainder owner in respect of the effective disclaimer of their interest. What you'll then sometimes see is a deed of arrangement to vary the terms of the will. So you have a situation where there's a particular interest created by a will. There's a bit of a dispute amongst the beneficiaries about who should have that interest or what it extends to. And the family and the beneficiaries and the executor will enter into what's called a deed of arrangement to vary the will. And so that will vary the life interest or the equitable life or the equitable remainder interest. So that's where we're creating a testamentary trust, for example, and we're giving that interest via the will. Then we need to look at this provision if we then vary it. If there is a section 128(21)(d), which states that if the deed of arrangement meets the requirements of that section, there are no tax consequences of the deed of arrangement, so either winding it up or varying it pursuant to that section. The requirements in order to meet that section is that it's to settle a claim to participate in the estate, and any consideration is given by the beneficiary consists only of a variation or waiver of a claim to an asset. So in essence, what they're talking about there, if we have the scenario where someone's given a life interest under a testamentary trust or under a trust under a will, and they say, well, I don't want that interest. I want you to give it to Sam, and I promise not to make any claim against the estate. Then potentially you will fit within that section. So in order for the first part about settling a claim to participate in the estate, a claim doesn't have to be commenced, but you have to be able to show that a court would have entertained their application for family provision. As such, a claim may be established merely by a beneficiary communicating to the trustee of their dissatisfaction with the will. So we have somebody saying, I don't like the fact that Sam got that life interest to that property. I want it. I'm going to make a claim against the will, or I'm unhappy with the way that the will is. That would be enough to satisfy that requirement under 128(20). So we won't have any tax consequences if we're winding it up due to that deed of arrangement to vary the will. How about the death of the person by which the life interest is measured? So very often that will be the person who's given the life interest, but sometimes that will be measured against somebody else. So there might be a life interest given to somebody to reside in a property until the death of another person, for example. If it's measured by the death of the person that is the person that is granted the interest, then if we wind it up on the death of that person, CGT event C2 occurs pursuant to section 102(45). A capital gain is made if the capital proceeds made from ending the asset is more than its cost base. When no capital proceeds are received, section 116(33)(a)(1) provides that the market value substitution rule does not apply when CGT event C2 occurs. So if it's measured by the death of the interest owner and they die, we have CGT event C2. If there's no proceeds received on their death, which there usually isn't, then that is disregarded, or there's no taxation consequences of C2. If the life interest was measured by the life of the owner, any capital loss is disregarded under section 128(10), I should say. In respect of the trustee or the remainder owner, if the trustee or remainder owner becomes absolutely entitled to the asset, so we have the scenario where the property is held on trust up until a person passes away. That person passes away. what's the tax consequence to the trustee or the remainder owner? They become absolutely entitled to the asset against the trustee, then CGT event E5 in section 104.75 occurs. That doesn't apply if the trust is a unit trust or a trust to which Division 128 applies. Division 128 are effectively deceased estate trusts, so the period while the deceased estate is being administered. Commissioner takes the view that it doesn't apply to trusts in their normal sense. So if for whatever reason we have a trust created now that creates a life interest with the property then going to a remainder owner on their death, then we're not going to have that carve out there. The remainder owner would make a capital gain if the market value of the asset at the time they become absolutely entitled to it is more than the cost base of their interest as it relates to the asset. However, if the remainder owner didn't pay anything to acquire their interest, very often that's the case in the trust capital, and did not acquire it by assignment, the Commissioner will take the view that any capital gain or loss is disregarded pursuant to section 104.75(6)(a). So in that scenario, again, if we're not actually receiving any proceeds or we haven't received the ownership by assignment, then we're not going to have any tax consequences to either the life interest owner or the life interest holder or the trustee or the remainder owner. What about a request to wind up the trust and distribute the assets? So in that circumstance, in relation to the life interest owner, if they come forward and say, I want my property now no longer held in the trust, and they have the ability to do so, then CGT event E6 happens if a trustee of a trust disposes of a CGT asset to a beneficiary in satisfaction of their entitlement. So this is one of those strange CGT events where both the trustee of the trust and the life interest owner make a capital gain under CGT event E6. For the life interest owner, the CGT event is not disregarded because they didn't pay anything to acquire it. The main residence exemption can't be applied. For the remainder owner, CGT event E7, contained in section 104.85, occurs. Again, it occurs to both the trustee and the remainder owner. In relation to the trustee, they make a capital gain if the market value is more than the cost base, and I should have said that about E6 as well before, my apologies. For the remainder owner, they make a capital gain only if they acquire their interest by making a payment. So a slightly different interpretation than for the remainder owner if the asset is passing to there. So the sort of scenario where that could occur, we have the trust established, the life interest owner is still alive. There's an agreement reached where it's then distributed to the remainder owner. We would have a taxing event to both the trustee and but we would not have one to the remainder owner. We would have a taxing event to the life interest owner as well. What about if we have dealings between the life interest owner and the remainder owner? So they strike a deal to either surrender or release their interest. If that occurs, if a life interest holder or remainder owner surrenders or releases their interest, the Commissioner takes the view that CGT event A1 occurs in 104.10, as there's a change of ownership of the interest from one party to another. If the surrender or release is for no consideration, then the market value substitution rule will apply to determine the capital proceeds from the event. So if you have an arrangement, as I said, where either the life interest or the remainder interest surrenders or releases their interest, in essence, we have a transfer of the asset, we will have a capital gain in that circumstances. What about the life interest owner and a third party? What if they decide to sell or assign their life interest to somebody else? Again, or they surrender it on the basis that a third party who's not the remainder owner pays them amount. Same analysis applies as above, with CGT event A1 occurring. They're transferring an asset, so CGT event A1 occurs. How about dealings between the remainder interest owner and a third party? For this, we have CGT event E8 occurring in section 104.90. So that occurs if a remainder owner disposes of an interest in the capital of a trust. That's, however, only applies provided they did not give any money or property to acquire their interest and didn't acquire it by assignment. Again, the market value substitution rule can apply. However, it is important to recognise that the interest that's relevant for CGT purposes is the interest in trust capital of the remainder interest, not the interest in the actual underlying asset. That's because of section 116.34. So again, we have a CGT event if there's a dealing between the remainder interest owner and the third party. If CGT event E8 can't occur because we didn't give money, or because we did give money, I should say, or property to acquire their interest, or we acquired it by assignment, then we're back to CGT event A1. So we will have, again, a CGT taxing event in that circumstance. Moving on to legal life or remainder interests and winding them up. So this is where we don't have the equitable interest, so we don't have a trust involved. We have effectively what you might want to consider joint ownership of an asset between the life owner and the remainder interest. Again, the different ways that might occur if we have a disclaimer of the life of the remainder interest. If it's effectively disclaimed, so we've got to do it as soon as we become aware of the interest, we need to have not received a benefit. It has to be intentional and to show exactly that we mean to disclaim it. Then, in essence, no CGT event can occur on an effective disclaimer, and the original transfer to them is void. So it goes back to the original owner. It has the effect of leaving the remainder owner with the entire fee simple, as it's known in property law. If the remainder interest is disclaimed, the remainder revests in the original owner, or in the case of a deceased estate, in the residuary beneficiaries. How about the death of the life interest owner, where we have a legal life or remainder interest? When that occurs, CGT event C1 happens, pursuant to section 104.20. If a capital gain or loss is made by the life interest owner, though, it's disregarded under section 128.10. In respect of the remainder owner, if the life interest owner dies, there are no CGT consequences. If there is a transfer of interests between the owner, then again, CGT event A1 would occur with the same analysis as earlier. How about winding up a right to occupy? And this is where we don't have an equitable interest, so we don't have a trust type relationship, and we don't have a legal interest. So we don't have an actual ownership of the property. We've been given a right to occupy or a right to reside. If the right relates to a main residence, then a right to occupy is an ownership interest in a dwelling for the purposes of the main residence exemption under section 118(131). So we don't actually have to have a legal real property interest in our main residence in order to apply the main residence exemption. In some circumstances, such as these, where we're given a right to occupy, it's an ownership interest for a dwelling. If we then meet the requirements of the main residence exemption, for example, it having been a dwelling of ours, then we're able to use the main residence exemption in 118(130). So as such, any capital gain or loss may be disregarded on winding up a right to occupy if we can show that it has been our main residence and we're given that right to occupy. How about granny flats? So as I mentioned before, relatively new introduction, Division 137, which gives CGT exemptions if we're entering into, varying or terminating granny flat arrangement that meets the requirements. So in order to meet those requirements, we've got them listed there on the screen, but I'll go into them in a little bit more detail. So the individual being granted the right must have either reached pension age or have a disability that means they require assistance for most day-to-day activities for at least 12 months. So either we've reached pension age or we have a disability that means we require assistance. An individual must either own the dwelling or they've agreed to acquire the dwelling. Both must be parties to the agreement. The agreement must be in writing and indicate an intention to be legally bound to the agreement. And it can't be on commercial terms. So it can't be granny flat at commercial rates. So if we meet all of those requirements, then there is a CGT exemption for either entering into the granny flat arrangement, varying it, or terminating it. So this is not something that we're going to be creating under a will, is it? Because we need both to be parties. It's got to be in writing and legally binding. So it's more an arrangement that would be entered into during the lifetime of a person. But if we meet those requirements and we're given somebody a life interest or a right to reside as it relates to a granny flat, then there's going to be no CGT issues with granting that right. Cost base issues for a property subject to a life interest. So generally speaking, there is an obligation to keep records of cost bases of CGT assets under Division 121. So in terms of the two mentioned being third element and fourth element costs, third element's costs include interest on money you borrow to acquire, in this case, the property subject to life interest or the life interest, costs of maintaining, repairing or insuring it, interest on money borrowed to refinance money you borrowed to acquire it, or interest on money borrowed for capital expenditure. And fourth element costs are capital expenditure to increase or preserve the asset value, which can include things like legal actions, or capital expenditure of installing or moving the asset. So if you think about this, how this might apply cost-based purposes for a property subject to a life interest, it is only really going to apply, of course, to the trustee or the person holding the property. It's going to have really limited application. And in situations where we're dealing with main residences, we're not going to really get into this world in terms of third element and fourth element, because our capital gain will be disregarded if we're meeting the requirements for the full exemption. So it's really going to depend on whether the taxpayer needs to keep the records as to what the sort of property we're dealing with, what sort of interest that we're granting, those sorts of things. I guess at the end of the day, if we get to a situation where we have a taxable event and we haven't kept the records, we can't claim it as a cost base. So it's the taxpayer that's losing out. They may be at a disadvantage. But in many circumstances, this is not going to be a live obligation. How about land tax implications if we've got a property that's held with a life interest or a right to reside attached? So in the states listed there on the slide, there can be an exemption if it's granted via a will and if it's used as a main residence by the person who's given the right, whether it's a life interest or a right to reside. Each state has slightly different requirements and slightly different interpretations. But the easiest way really is to go to the revenue page for each of the states. And if you do a search on life interest or right to reside by will, it'll step out what the obligations are. But the short answer is we should be able to get a land tax exemption if the property is held with a life interest or a right to reside attached, which has been granted by a will. If you do need, we can send you the links to the specific webs or parts of the websites of each of those revenue authorities. But yeah, you'll be able to, again, if your drafting is right, get yourself into a position where there's a land tax exemption as well. If it's another version of a trust, such as a discretionary trust, and it's not created by will, we're not going to have those exemptions apply, and there's going to be land tax payable. So moving on to our case study, having just consideration of a few of the different taxing points of a life interest in the life cycle of a life interest and remainder interest in the property. So we've got the Fowler family, Doug. Doug's married to his second wife, Carla, and he has two sons from his first marriage. So we've got Amir, who's got some drug dependency issues, and we've got Moheb, who has a slight intellectual disability. In terms of that intellectual disability, it leaves Moheb to be easily taken advantage of. Amir's drug problems are pretty bad. So in discussions between Doug and Carla in terms of their estate plan, Doug agrees that the assets, aside from his main residence, should be split equally amongst Carla, Amir and Moheb, but he also thinks that they're going to need some protection, both of his sons. So conversation, of course, turns to the use of trusts and testamentary trusts. In terms of the main residence, because it has some sentimental value and Carla has her own property separate to the main residence, because second relationship, as is often the case, Doug's decided that he would like to leave the property to Amir and Moheb, again, via a trust. However, he'd like to give Carla the right to occupy during the term of her life. So the property passes to the trustees of Amir and Moheb's trust, whoever they are going to be, created under the will, but Carla is given a life interest. So that's the plan. That's what's put into place. main residence goes to the two testamentary trusts with the life interest granted to Carla. The rest of the property gets split 3 ways. In terms of the structure of that, because he's got concerns with Amir and Moheb, that's meant to say trusted second person, but there's a second person appointed as co-trustee of those testamentary trusts, and the assets are split in terms of the main residence between the two testamentary trusts, and their third of the balance of the estate also goes into the testamentary trusts. Main residence gifted subject to the life interest to Carla. Some of the requirements of that life interest being the maintenance insurance to be paid by the trustees of the testamentary trust. Carla can renounce her interest, but she can't substitute. So that's our strategy, and that's what's implemented. Now, unfortunately for Doug, he passes away shortly after implementing the estate plan. And so the property, as part of the administration of the estate, passes to the trustee of the two testamentary trusts on the basis that a right to occupy is given to Carla. So in terms of that and that administration of the estate, no tax issues caused by that. It's passing under a will. We have a cost base for the trustees. We have a cost base of the interest for Carla. As the property is her main residence, it should also be exempt from land tax because she's given a right under the will. So during the administration and the early doors days of the estate, no issues from a tax perspective in relation to the property. Then we start having some hiccups. The first hiccup being that Moheb doesn't want to continue to hold the property. He's fallen, as I mentioned, he's easily persuaded, and he's fallen under the influence of his biological mother after the passing of Doug. And so he's decided he doesn't want the hassle of owning the property. He wants to take all of his cash from that. He doesn't want to have to keep dealing with Carla, and he wants to invest in cryptocurrency rather than the property. So he goes and discusses with Amir about a buyout of his half interest of the property. If it was to occur, then CGT event A1 is going to occur. It's going to occur to the trustee of Moheb's trust. So we would have a capital gains tax event. If our proceeds are more than the market value of our property, then we would have issues there because we're doing a buyout here. Stamp duty would also be payable on the transfer. They're going to reach an agreement in principle that Amir is happy to buy out Moheb's interest. However, then they go and get a valuation of the property. Unsurprisingly, as Carla is given a life interest to occupy the property, and she still has, in statistical terms, 20 or so years to live, that impacts the value of the property because you can't use it until she passes away or renounces her interest. So the value of the property is not half of the market value of the property, it's reduced by the impact of the life interest. So Moheb decides not to proceed. We're then on to our second hiccup, and perhaps unsurprisingly, Amir runs off the rails and his drug problems return, and Moheb becomes increasingly antagonistic to his former stepmother. Maintenance falls behind, bills don't get paid, Amir is often uncontactable for long periods of time, so Carla decides it's all too hard and surrenders her interest for no consideration. She goes, well, I'm just going to go back to my house, I surrender my interest. We can think about the CGT implications by reference to earlier parts of the paper, but considering she's been given a life interest, she has surrendered it for no consideration, there's not going to be any tax consequences caused by the surrender of that mere right to occupy. Stamp duty, we should also think about. There have been some changes in some of the states about interest in property. We would have to review that, but again, it's very unlikely to be a stamp duty issue on surrender of the interest. But as I said, as there's a right to occupy, there shouldn't be any stamp duty issues, but it's still something that we need to tick off. So that is the end of the paper. I should say before Kate comes back on the line, we do have a written synopsis of this paper and the points covered. If you'd like to, I'll include a question on the feedback form. If you'd like a copy of that paper emailed to you, let me know. And we'll email it to you once you've completed the feedback form. I'll pass back to Kate.
Thanks, Adrian. We do have a couple of questions. I see the questions there from Oren and Malav. I hope I'm pronouncing those names correctly. We will probably come back to you two separately on those scenarios because there's a bit that we need to work through with them. And I also note the questions from Maria. They're a bit outside the scope of today's topic, so we'll come back to you separately as well. Other than that, I don't see any questions to give to you at the moment, but as I mentioned at the start, if anyone does have any particular queries or any client scenarios that you'd like some feedback on, feel free to reach out. Adrian did mention just then that there will be a feedback email circulated later today, I believe. As always, if you could just take a bit of time to complete that survey, it should only take a couple of minutes. We would be really grateful for your feedback. And as always, if you have any ideas or suggestions for future topics, we'd be more than happy to take those into account as we plan for future webinars. So thank you everyone for attending. If there's nothing further, I think we'll close it out there.
Okay, thanks everybody. Complex topic. Hopefully it didn't send you to sleep, but if I did and you missed something, just reach out to us.